Good day, I bid to Madam Rosniza. We begin the presentation with the definition of injunction. What is an injunction? Injunction is an order that prevents a person it is addressed to from executing a certain act or compels him to execute a specific act. The overriding object of an injunction is to protect and preserve the legal rights and interests and to prevent the commission or continuation of a legal wrong. Firstly, under temporary injunction, it deals with temporary orders that are typically written to last until the trial or until further notice. In emergency situations, normally, it functions to safeguard an immediate right until the court has time to consider the dispute at trial. For example, in contractual, property, and tort disputes are few circumstances in which this type of injunction can be requested. Next is permanent injunction. Stated in Section 37, Subsection 2 SRA, a permanent injunction can only be issued by a decree following a hearing and based on the case merits. To put it simply, a standard lawsuit must be launched in order to acquire a permanent injunction. In this lawsuit, the right being sought is evaluated on its merits, and then a judgment is issued granting the injunction. Therefore, a permanent injunction determines a person's right in a final manner as opposed to a temporary injunction. Next, mandatory injunction. It functions to put things back to how they were before the defendant's contract violation. An injunction may be granted. For example, it includes scenarios in which one of the contract's parties refuses to fulfill their obligations. To compel someone to obey instructions such as signing the documentation needed for a land transfer, a mandatory injunction may be requested. And lastly, prohibitory injunction, where it is a court order compelling a party to refrain from doing a specific act or object. Since they prevent further injury, interim injunctions are the most common approach to obtain them. The most frequent ones are those that violate contracts. Moving on to the effects of injunction, it varies according to the type of injunction that is being sought. To illustrate, a person requesting for prohibitory injunction will cause certain acts of the other party to be prohibited if satisfied by the courts. Moving on to the significance of injunction, the main aim of an injunction is to prevent acts that can lead to further damages and expenses. For instance, in most cases, the injunctions are always there to stop the ongoings of something or to prevent somebody from going into a particular area. Since a case cannot be adjudged in a day, the court must, in some circumstances, grant equitable remedy injunction to prevent the victims from entering into more losses, since the litigation will take time before judgment.
We can see that it is the court's power to grant injunction in accordance to Section 54 of Courts Judicature Act 1964. Section 44 of the CJA allows the Court of Appeal to grant any interim order to prevent prejudice to the claims of parties pending the hearing of the proceeding of the appeal. It also allows for the grant of wide forms of relief, and there is no real limit to the type of orders to be granted. Next, Order 29 Rule 1 of Rules of Court 2012. Regardless of whether a claim for an injunction was included in that party's originating process, counterclaim, or third-party notice, as the case may be, any party to a cause or matter may apply for one either before or after the cause or matter is tried. Chapter 9 of Specific Relief Act 1950 in Section 50 and 51, where Section 50 stated to provide relief from the problem beforehand, the court may issue a temporary or permanent injunction. Section 51 mentioned temporary injunctions are those that must continue for a specific amount of time or until the court issues a new ruling. They are subject to civil procedure law and may be granted at any point during a legal proceeding. The decree entered at the hearing and on the merits of the case bars the defendant from asserting any right or from acting in any manner that would violate the plaintiff's right for the rest of time. Lastly, Chapter 10 of Specific Relief Act 1950 in Section 52, 53, and 54. Section 52 explained on the situation where perpetual injunction is granted. Meanwhile, Section 53 stated the court may, in its discretion, grant an injunction to stop the alleged breach as well as to compel performance of the necessary acts when, to prevent the breach of an obligation, it is necessary to compel the performance of specific acts that the court is capable of enforcing. Lastly, the Section 54 further explained on when injunction is refused. The courts recognize certain circumstances in which monetary compensation is insufficient to undo the harm. For example, if someone wants to prevent someone from releasing false information about them, it is because they are concerned about the impact on their reputation. No amount of compensation can compensate for the damage to their reputation caused by the publication of the defamatory content. Because of the harsh consequences an injunction has on the party against whom it is granted, Malaysian judges rarely grant them. In most cases, convincing the judge to rule in favor of the plaintiff would necessitate substantial evidence. Assalamualaikum warahmatullahi wabarakatuh and a very good day. My name is Nur Fatiha binti Muhammad Rizal, matrix number 280793. And today I will be explaining the factors the court considers before granting an injunction. So as we all know, courts have the discretion to grant an injunction and therefore will consider a variety of factors to prevent abuse. The House of Lords actually established the principles or factors for granting injunctions in the case of American Cyanamide Company against Ethicon Limited. So in this case, the appellant was a company that held a patent for artificial absorbable surgical sutures. The respondent was a company that intended to launch a suture to the British market, which the appellant claimed was in breach of its patent. At first instance, the appellant was granted an injunction preventing the respondent's use of the type of suture at issue until the trial of the patent infringement. On appeal, the Court of Appeal discharged an injunction on the basis that the case for patent infringement was not made out. The appellant appealed to the House of Lords. So the issue in this case was these facts was primarily the extent of any substantive claim necessary for the grant of an interim injunction. So the House of Lords, however, set out detailed guidelines with regards to how the court should deal with the grant of interim injunctions in general. So the principle set out was later followed in the Malaysian case of MD Rashid Masrukin and another against Lee Chi Seong and others, where the court applied the principles set out in the case of American Cyanamide in granting an injunction. So moving on, I will be explaining the principles set out in the case of American Cyanamide Company against Ethicon Limited. So the House of Lords actually set out 4 principles that needs to be followed in order to grant an injunction. The first one being whether a serious question should be tried. So the court will examine it on the surface, and no injunction will be granted if there is no serious question to be tried. Second, whether the damages are adequate to compensate the plaintiff. If damages are adequate to compensate the plaintiff, then no injunction will be granted. Third, a balance of difficulties. Simply put, if not granting the injunction causes plaintiff more hardship than the defendant, then an injunction will be issued out by the court. And lastly, the plaintiff should always provide a complete and frank disclosure of all material information concerning damages.
Assalamualaikum and may peace be upon you. My name is Haris Daniel and I'll be moving on to the next slide on the principal layout in the case of American Cyanamide. To explain more detail about the balance of convenience. The balance of convenience is a type of test considered by the court intervening the granting of injunction to the plaintiff. This type of test shall arise when there appears to be a doubt regarding the adequacy of damage to the claimant or defendant. As law developed in American Cyanamide, he emphasized that there shall be 3 considerations in determining the balance of convenience. The 3 considerations are the preservation of the status quo, the strength of the case in relation to the opponent, and other special factors. Now let's go to the first consideration, the preservation of the status quo. Status quo by definition is the existing state of affairs, and by preserving the status quo, it means the halting of any activity conducted by the defendant before a trial. So this consideration will be taken into measurement if the defendant adjured to do something which he never done before. Example, the halting of his business activity before the date of trial. However, if the defendant can show that the cost and inconvenience caused by granting an interlocutory injunction outweigh the benefit and justice for the applicant, it is unlikely that an interlocutory injunction will be granted. In addition, if the defendant has not yet started acting in the allegedly illegal manner, then the balance of convenience will normally favor the grant of an injunction. If they have begun acting, then the balance of convenience will favor not granting the injunction. This can be seen in the Malaysian case of Syarikat Tunggaring Kilang Papan versus Sabah Forest, where the defendant's activity of logging is for the purpose of public interest in producing papers, and the defendant had worked half the allowed acres of the forest despite the refusal to get a license when the progress to renew the logging license is at 99%. Moving on to the next is the strength of the case in relation to the opponent. This type of consideration will be relevant in the case in which the fact of the case may be deduced from the evidence that has been adduced by one party is not subject to credible dispute. To explain, in a situation where the disadvantage conferred by both plaintiff and defendant does not differ widely, the court will look into the strength of the case based on the evidence and arguments presented. An example can be seen in the case of Intel Corp v Intercut, where both plaintiff and defendant are software company that shares a similar company name. Is in a dispute over the right of the name Intel. The court, after assessing the affidavit adduced in favor of the plaintiff, granted an injunction to stop the defendant from using the name Intel, since the name is synonymous with Intel Corporation, and misuse of the name could taint the plaintiff's reputation as a mega corporation in software. Lastly, it is special factors. Special factors is other factors that court will consider in granting an injunction. Such an example can be seen in the American Cyanamide case itself, where in this case, the plaintiff sought for an interlocutory injunction to stop the infringement of its patent when the defendant intended to launch a surgical suture in the British market. The factors which the court took into consideration were that Ethicon Sutures XLG was not yet on the market, so they had no business which will be brought to a stop by the injunction. So no factories will be closed and no work people will be thrown out of work, which means the injunction cannot be given if the conduct does not happen. That is all from me, and I will pass the presentation to the next presenter.
Moving on, we will further explain on this situation where the application of the injunction cannot be granted by the court. These situations are actually stipulated in Section 54 of the Specific Relief Act. In simple words, the first situation provided in Section 54A is usually arise when the applicant sought injunction without necessary purpose like to prevent multiple court proceedings, but instead it is sought for pending of judicial action from happening. For example, in the case of Datuk Sri Andrew Kamtayu against Embang Malaysia Berhad, the claimant actually defaulted in loan payment even after both parties had agreed in the global settlement. The plaintiff then sought injunction to restrain the defendant from proceed with the bankruptcy action since both parties are in proceeding where the plaintiff claimed his right over the property redemption under implied term. So, the court dismissed the injunction as they believe that there is no merit in the plaintiff claim and upheld that it is the Embang Berhad's right to proceed with the bankruptcy action due to plaintiff default. Next, as for Section 54B, we shall take a look in the case of Bina Satu Sendian Berhad against Tan Construction. In this case, the defendant applied the injunction to restrain the wind-up petition to prevent it from ruining and cause damages toward the plaintiff. Plaintiff added that the defendant is aware that the claim is disputed as there is no contractual relation between them. Hence, the petition of winding up is an abuse to pressure the plaintiff to pay matters that they are not liable for. The defendant then brought out the power to grant injunction on inherent jurisdiction, which is against the prohibition under Section 54B. The court then stated that they have the jurisdiction to enjoy inherent powers that include restraint and abuse of its proceeding, which is done by the defendant, for instance. Hence, the court overruled the defendant's objection toward the grant of injunction. As for the situation of Section 54D, which similarly with Section 29 Government Proceeding Act, the injunction shall not be granted if it against the government and will interfere with the public duties of any department of Malaysia's government or sovereign act of foreign government. The best case to illustrate the case is Tidal Marine Engineering Sendian Berhad against Kerajaan Malaysia. In this case, the plaintiff sought injunction to prohibit the defendant from receiving as beneficiary the amount in the bond given as condition of the project awarded. It is due to the defendant reasonably terminate the project. The court, however, dismissed the injunction as they observed the money received from the bond is used in that project, which is for the benefit of the citizen. As by granting the injunction, they believe it will interfere with the duties of the defendant as government in their public duties to provide infrastructure for the citizen. Lastly, no injunction can be granted purposely to stay proceeding in criminal matter. For instance, MRA International Sendian Berhad against SPC Diatech, the plaintiff fraudulently used the defendant business name and deceived the client into thinking that they are still a defendant exclusive agent. For that reason, the defendant sent the letter to the client to clarify, but was claimed by the plaintiff as defamation. The parties then sought injunction to stay in the defamation proceeding to restrain the defendant from initiate criminal proceeding in foreign jurisdiction against the plaintiff. The court, in addressing the issue, held that whether or not the defendant had prepared to initiate claim against plaintiff, the injunction will still be dismissed as it was prohibited to grant for purpose of staying in criminal proceeding.
Assalamualaikum and good day to Dr. Ros and my fellow friends. My name is Ain Nadira Betisukufli with matric number 280557. We will continue to briefly explain in regard to the situation where the court refused to grant the injunction as stated under Section 54 of the Specific Relief Act 1950. Subsection 4 explains that an injunction cannot be granted to prevent the breach of a contract, the performance of which will not be specifically enforced. So, by the basic case of Sukhami Transit Project Sendian Berhad against Prasarana Malaysia Berhad, the court dismissed the application for injunction that made by the plaintiff against defendant due to the plaintiff had breached the contract due to the failure to renew the performance bond after it had expired on 25 April 2016, which had been provided under clause 4.2.1.2 of the principal contract. Meanwhile, subsection G expanded. The court won't grant an injunction with such to prevent reason which is not reasonably clear it is will be a nuisance. In the case of Chir Moyen against Chai Wen Singh, the court discharged the injunction since the plaintiff failed to prove that the defendant had interfered the plaintiff from use and enjoy their property. Next, Section 54 Subsection I of the Specific Relief Act 1950. An injunction cannot be granted when equally effective relief can certainly be obtained by any other usual mode of proceeding, except in case of breach of trust. This can be seen in the judgment of 1 Emerald Residence Sendian Berhad against Asian International Arbitration Centre, where the court dismissed the injunction application to stay the adjudication proceeding pending the disposal of a judicial review application since it will bring hardship to the respondent. Subsection J explains that an injunction cannot be granted when the conduct of the applicant or his agent has been such as disentitle him to the assistance of the court. By the virtue case of Colton plus Soltis Berhad against Teo Sang Yap, the court held that to dismiss the injunction due to the failure of the plaintiff to show there are serious questions to be tried, together with the fact that there was an abuse of process during the course of the granting the interim injunction. Last but not least is Section 54 subsection K of the Specific Relief Act, where it explains that injunction cannot be granted when the applicant has no personal interest in the matter. This can be illustrated under a Protronic Semiconductor Siram Berhad against Chan Ah Chew, where the court dismissed the application for injunction that made by the applicant, since the applicant having no personal interest in the subject matter.
To summarize, injunction is an equity-based relief. It is completely at the court's discretion to grant an injunction or to refuse it. It is better for the courts to have power to grant an injunction rather than to derive it from any rule or law, as this requires a lot of time. In our temporary society, there is an evolution in every aspect of human life and the discovery of many other new things and ideas. Because of these changes, it will be difficult for the judges to sit in judgment without taking into account the facts of the case and their concise, because there are so many activities and crimes that are still undocumented, and by the time they are, most of them have progressed to a more advanced stage and complicated problems. Therefore, in order for the judges to consider new issues and have sufficient time to handle a case, an injunction must be first granted.